Just a minute. There we go. And we will record and we will recirculate this. We had so much excitement over the Neora podcast. People were just clamoring to get the replay, and it went very, very well. There's Howard. Hi, Howard.
Hi there. How are you?
Welcome. Fine. Thank you. I hope you're doing well. All right. We've got a great group on the call. In case you don't know me, I'm Donna Marie Saratella, and I'm the one that puts on the direct selling podcast, the direct selling show. Let's make this bigger. Okay. Well, we're going to go ahead and get started. If you would like to put your name or your email in the chat, we're going to be communicating with you. And in the chat, if you'd like to list your name and say, I'm a winner, I have Doris Wood's books. Still, I have tons of them and I'm moving, so I need to get rid of them. So if anybody wants Doris Wood's books, she has a book on definitions and a book on the history of direct selling. Just put it in the chat, I'm a winner, and put your email and we'll send you a copy. All right, let's get going. We've got a lot to talk about today. So we have special guests today, Howard Smith, the Deputy Director of the DSSRC, the direct selling, I just lost it. The Direct Selling Self-Regulatory Council. And Peter Marinello, the Vice President of the DSSRC. We're thrilled to have them with us. And then again, we have Kevin Grimes back for the umpty-ump time. We've been doing this show now for years. It's been since COVID, and sometimes it's just been he and I on the show. So we're really glad you're here today. That helps us a lot. So we've got on previous shows, we've put forward a lot of the links to the FTC business guide and the testimonial and advertising. If you need any of those links, just email me. I'll ask Patrick to put up my email address. Send me an email at directsellingsolutions@gmail.com, and I will get you those publications. So let's talk for a minute, just a minute, about what I do. I offer compliance training workshops. In October, we will probably have one. I just sold my house this morning and they want me out in 15 days. So I'm going to be busy. I don't think there'll be a show in September. So bear with us while we get resituated. Anyway, my focus is on speaking, writing, and teaching. I have a company by the name of Speaking of Solutions. And if you'd like a fresh note on compliance education, give me a call. I provide compliance presentations. We do skits. We do training about compliance. It used to be just a nice thing to have the compliance person at your annual event. Well, now, after the Neora decision and after what we've seen in the community about having robust compliance activity, it really is important to have compliance education at your events and conferences. So let me know how I can help if you want to have a compliance booth or get a little name tag that says, what would compliance think? A little badge for your arm or whatever. Whatever you can do to increase your compliance visibility in your company is what we suggest that you do. So let's get started with some introductions. Before I do, I just want to tell you the show is hosted by the Institute for Global Compliance, and I'll get into that a whole lot later on another show. But the Institute for Global Compliance was formed a few years back. Doris Wood and myself and Troy Dooley pulled it together, and it's to provide affordable compliance education, transparent education for the direct selling professionals. So just like this podcast, the Direct Selling Show, will never be a charge for that. We will charge for training in the future, but for right now, everything is very affordable because it's free. So we're ready to rock and roll. Let's get going. Now, no one knows who's going to be next with the FTC. No one knows. And I don't mean to get people concerned about it, but it would be something to consider and get your defenses up now. When a crisis arrives, it's just too late for preparedness. So get your act together before it's too late. Now, most of you know me. I'm the queen of compliance, and I do put my crown on for this little section. I'm a writer, speaker, and a compliance expert in the industry since 1991. And over the years, I've provided compliance training and set up compliance departments in direct selling companies. Now, my focus has shifted quite a bit lately because I'm very focused on my second book, which is going to be called Almost Everything MLM. And it will be for the direct public, the public to learn about direct selling. So my focus has shifted to that. I'm speaking, writing, teaching exclusively in the direct selling industry. And remember, the Queen of Compliance is always watching. So let's talk about our guest today. But before we do, I want to just mention our sponsor is Thompson Burton Law Firm. They have offices in Nashville, Franklin, Tennessee, and Huntsville, Alabama. They have over 42 lawyers and 4,100 cases won with over 27 happy clients. Kevin is part of the Thompson Burton family. And the bottom line is our sponsor can cover you for whatever your legal needs may be. So give them a call today. And we're going to move on now to our guests. All right, let's do our introductions. Well, the name of our show is Blurred Lines, the truth about playing within the lines and what companies need to know when the lines actually move. And they have been moving lately. So allow me to introduce our representatives from the DSSRC. I'm tongue-tied today. And as we said, the Direct Selling Self-Regulatory Council. Howard and Peter, many of you already know them. So for those of you that don't, they're wonderful, well-educated gentlemen that will just teach you so much about this industry. They are, we could do 3 shows with these 3 guests because they're just so full of industry knowledge. So Peter Marinello is the vice president of the DSSRC. Peter is involved with the BBB National programs. In his role, he serves as the director of the BBB National Programs, Direct Selling Self-Regulatory Council. And what that is we're going to talk about what it is, but it's a national advertising self-regulation program specifically for the direct selling industry. So Peter has over 25 years of experience in advertising self-regulation, starting as a staff attorney at the Council Better Business Bureau. Peter's written over 2,000 self-regulatory decisions. That is amazing, Peter. I can't imagine doing that much work, but I'm sure you have done it on various advertising topics and products, including earning claims, health and safety claims, online advertising, negative option offers, dietary supplements, nuclear energy, and financial services. Peter has spoken on behalf of advertising self-regulation at trade conferences, workshop seminars throughout the country. He's also authored a number of articles regarding advertising self-regulation in various trade publications. So he really knows his stuff. Before joining the BBB national programs, Peter participated and practiced law for 6 years at a general litigation firm in New York City. Peter received his bachelor's degree in New York University and is a graduate of St. John's University School of Law. And he's been a member of the New York State Bar since 1988. Wow, that's some introduction, Peter.
Oh, you're on mute.
We can't hear you. You're muted.
You're on mute, Peter.
There you go.
I was going to say it's always a good move to mute me as Howard sometimes doesn't get a chance to speak enough. So we have this hashtag let Howard speak because I'm constantly unfortunately tripping on his words. Donna Marie, thank you for that very kind introduction. Wow, what a pleasure to be here with the Queen of Compliance. I hope you trademarked.
Thank you so much for joining us. Let me ask you real quick, what was your motivation to get involved as an attorney? What got you thinking that way?
Oh, what a great question. I'm going to fall back on the public interest piece, actually, because there are a lot of different legal positions out there. But doing something that advances consumer protection and really leveraging the playing field so businesses can operate fairly, that was kind of the idea behind it. Sure.
Well, fantastic. Well, we're glad you did it, and we're glad you're part of the DSSRC. It's wonderful to have you here. Let's talk for a minute about the next speaker, Howard Smith. Got a mouthful about him. Sue sent me these huge bios, and I wanted to say them all, but there was just not enough time. So let's move on to our next speaker. Let me get this back up here. Howard is the deputy director of the DSSRC. And prior to joining the national program, Howard was a commercial attorney and litigator in private practice for a number of years. His practice included handling complex matters across a broad array of subject matters, including false advertising. I see a trend here towards this: false advertising disputes, intellectual property disputes, and bankruptcy matters. So Howard has a well-rounded knowledge in law and has a substantial trial experience, as well as experience counseling a wide variety of commercial clients. Howard's notable achievements for varied clients include successfully arguing an appeal to the Second Circuit for a Fortune 200 client, winning 2 breach of contract trials in New York State Court, and winning a defense verdict in a 2-week jury trial in a California state court. Howard also has significant experience in advertising disputes before the NAD, which is the National Advertising Division of the national programs. Howard, what brought you to the BBB platform?
So I was, as you mentioned, in private practice at a firm here in New York, and I was representing clients starting in the financial space in false advertising disputes before NAD, which is our sister program, which is right down the hall from me here. And so I was appearing in this forum and sort of seeing that it was what I thought was a really useful and productive alternative to the court system. And so I became kind of enamored with this as a forum for dispute resolution. It was efficient. It had subject matter experts. And I felt that, showing up here and arguing my case for my clients, I had a way better audience than going to federal court, where the judge had a slip and fall case before me and an insurance fraud case after me and a criminal sentencing after that. I had people that were really they lived and breathed false advertising issues. And I got, over one case became 10 cases, became 15 cases. And I got to know the folks over here and expressed an interest in moving over to the neutral dispute resolution side of things. I was in talks to join the National Advertising Division when they mentioned to me, we're starting a new program. This was in 2018. And they said, would you want to talk to Peter Marinello about this new program we're going to launch? And I came over here, chatted with Pete, and joined, and we launched this program 5.5 years ago. And here I am.
Well, fantastic. The industry is better to have the 2 of you at that organization. So we are very pleased to have you as our guests. Our third guest is Mr. Kevin Grimes, and we appreciate him so much. There's just so much that we can say about Kevin's journey in the industry. It began as a distributor, and providing him with a unique perspective and a deep understanding of the challenges faced by businesses, both on the distributor side and the attorney side. I think that gives him a well-balanced, rounded view of the regulations. This experience shaped his approach, making him a valuable asset to his clients and colleagues. Currently, Kevin is an attorney with Thompson Burton Law Firm, recognized as the premier law firm resource specializing in direct selling law. His commitment to his clients is unwavering, always making time to offer his guidance and support. And I have to add this because beyond his professional achievements, Kevin is admired for his exceptional character. He is a devoted person of faith, and he embodies the principles he holds dear. His compassion is evident by his personal life. He's fostered over 35 teenage boys and adopted 4 into his own family, demonstrating a heart truly bigger than Texas. So Kevin is amazing, and he's an exceptional individual whose impact extends far beyond the courtroom. So I'll stop because he's blushing. All right. So let's get going now. Patrick, if you could put Kevin's email in the chat, We are coming to you live from Las Vegas, and we're going to get going now into our engaging and informative show. Well, this session is titled Blur Lines, the truth about playing within the lines, what companies need to know when the line moves. So we want you to be able to take a confident step towards a compliant and successful future in direct selling. And that's why we're having the show today. So we're going to look at a couple of things. We're going to look at understanding the FTC's role in this entire situation, the role of the DSSRC, current regulatory climate, the moving lines, and staying within the lines. So we have a lot to chat about. An introduction to the FTC. Who wants to give it? Anybody? No, I'm kidding. The introduction to the FTC and its mandate to protect consumers and ensure a fair marketplace. Now, Kevin, can you give us the Reader's Digest condensed version of the role of the FTC pertinent to the direct selling industry in a nutshell?
Yeah, well, like you said, their charge, their commission is to protect competition, to protect consumers. We say competition, Howard alluded to this earlier in terms of creating a level playing field. And, that certainly is one of their overarching missions. Obviously, if, one or more businesses are allowed to engage in, any type of an unfair business practice, whether it's, something deceptive, that absolutely puts legitimate businesses at a profound disadvantage. And of course, the entire, legitimate direct selling industry has for decades had to compete with pyramids. So, but obviously they're equally concerned, if not more concerned, about protecting consumers. And in the direct selling space, we've certainly seen their interest in two primary areas. In fact, this was Commissioner Rohit, Peter Howard, correct me if I'm mispronouncing
Right.
his name, as well as Mr. Cohen, who I believe is now the director of the FTC's Consumer Protection Bureau, penned an article in a University of Pennsylvania law review publication a couple of years ago, saying that they set forth the commission's top 5 consumer protection priorities, of which direct selling made the list, one of the 5, and within that, as evidenced by their relatively recent pronouncements under the Penalty Offense Authority, they're looking at income claims, massively, which has been a perennial issue for the industry, as well as product claims. And I'm really curious to get Howard's and Peter's takes about what they think about the landscape right now. And we may be getting the cart before the horse. I don't want to drill down on tiny issues if we're still doing the broad brush strokes right now. But I'm really curious to get their assessments about where the FTC is under both of its penalty offense notices that some of which have been directed to direct sellers.
Absolutely. We can't talk about the FTC without talking about that Penalty Offense Authority. Those letters went out to a lot of people. So let's ask Howard about what he thinks about the FTC's position. Are they doing a good job being transparent, Howard?
Well, I mean, I think it's fair to say that those of us that have been following what's coming out of the commission, that the landscape, it's moved, right? We sort of say that the goal lines have moved in terms of the types of claims that we heard from the commission were I guess they would say, how would I say? It was almost a safe harbor for things like just modest and supplemental income, right? That's kind of what you heard out of the commission for a number of years. And if you look at the updated guidance that just came out regarding MLM marketing, it's pretty clear that almost any type of earning claim is going to receive regulatory scrutiny. And I think if you compare that to the 2018 business guidance, which if you read it, it essentially said that you could almost qualify a career level income claim with a proper disclosure. And now you're hearing, wow, even modest supplemental claims are going to be subject to scrutiny, and you're going to have to factor in expenses. So it's really a time where I think everyone in the industry is just very curious what's going to come out. There's also rulemaking, ongoing rulemaking with respect to earning claims. What is that going to look like? So I think we're all just kind of trying to process this really moving target. And what we've tried to do on our end is to say, well, okay, the commission they have what they put out. They have their guidance, which of course is just guidance, not necessarily what the law would be if there was a litigated contested matter. And we've just tried to give companies some guidance about what we think from a self-regulatory perspective are some basic rules of the road when it comes to things like earning claims.
Let's touch base with Peter and see what he thinks about the FTC's moving lines.
It's interesting. And again, I'm going to get back to Kevin's idea of not putting the cart before the horse here. And Donna, I'm going to actually go back to your original question. It talks about the mandate, right, of the FTC. And it all goes back right to Section 5 of the FTC Act, right, which prohibits unfair and deceptive practices. I mean, everything evolves from Section 5, where the FTC sits. And of course, the FTC's role, as Howard and Kevin mentioned, really revolves around protecting consumers and ensuring a fair marketplace. It's funny, when I look back at, on Section 5 of the FTC Act, the FTC came out with something back in 1983 that I kind of feel is almost the Rosetta Stone for claim substantiation, right? And that's the FTC's 1983 substantiation policy. And this is where the FTC essentially lays down the law. You need a reasonable basis for any product and income claims that are disseminated not just by the company, but by the sales force members as well. And then the idea of not disparaging, competitors out there, and particularly with product claims, I think that's where the bar got set, for the evidentiary threshold of having reliable and competent scientific evidence to support those type of claims. So Donna Marie, I thought we could start the discussion from there, and then you can kind of take us in whatever direction you feel appropriate.
Okay, great. Thank you, Peter. Before we get into the FTC a little bit more, let's get into the DSSRC. We've got folks on the line that may not be aware of that organization or just know a little bit about it. So Peter, could you share a brief introduction to the collaboration with the Better Business Bureau and the DSSRC?
Sure. As Howard mentioned, we launched DSSRC back in 2019. So we've been in operation now for a little over 5 years. And really the program started at the behest of the industry. And when I say industry, for purposes of this conversation, I just want to speak about the Direct Selling Association, because Donna, I was in the audience back in 2016 when the chair of the FTC, Edith Ramirez at that time, pointed out to the audience and essentially said, hey, direct selling industry, if you guys don't figure out a way to internally clean up some of these income claims and product claims, of course, in the background is the whole pyramid scheme thing, but if the industry doesn't clean it up, then we're going to step in and really impose some draconian measures that's essentially going to chill the way that companies do business. So the DSA, to their credit, they stepped up, they funded this self-regulatory program, but it was important that it be administered by an independent third party, and that's where BBB National Programs comes, right? So BBB National Programs, they've been in operation since, I want to say, 1971 with the National Advertising Division, which Kevin touched on and which Howard touched on. And so it's really built up this real credible administration of self-regulatory programs. Now, BBB National Programs just doesn't administer DSSRC and NAD, but they also have programs for privacy, for children's advertising, auto warranties. I want to say, Howard, that I think we administer 20 or so different self-regulation programs for different industries. And so, Donna, that's really how DSSRC came into being. But I do want to emphasize this one piece, because I touched on the DSA and what a pivotal role they played in the creation of the program. But it's important to remember that DSSRC is about the entire industry. We monitor DSA members, non-DSA members, Salesforce members from wherever and whomever, right? And that's an important piece. And the other very, very critical piece is maintaining that independence. DSA has no idea what cases we open, who we're pursuing, who we're talking to. And I think that brings some added credibility to the program, Howard.
It's a great organization. It really is. And the industry needed it so badly longer ago than it even got started. So we're glad you're here. Howard, how does the DSSRC monitor? Peter just mentioned about monitoring marketing and advertising practices. How do you do that? Do you have a bunch of ladies back there monitoring, or do you have a system?
So we actually work with two different third-party monitoring services.
Okay.
That's what they do. They go out, they scour the web for, I think they've identified close to 900,000 unique URLs that are associated with direct selling marketing. That's company websites, company blogs, Salesforce members, social media channels, and they cast this really wide net. And we give them the names of all the direct selling companies that we are aware of, so that they can, and obviously they're in any given month, for example, they're not reviewing the entire channel. So we kind of have companies on a rotation, as you were, and we have certain, I guess you'd call them high risk terms that we look for, and that leads to these posts or social media posts or website claims being flagged for us. We have these online portals where we can go in, and then we put our own human expertise on them, and we say, is that an actual hit? Is it a false positive? What are we seeing? Is there a trend? Or is there a company that, oh, wow, look, there's 10 bad claims here or 10 questionable claims. And through that, we kind of decide which inquiries to open. That's one mechanism. There's also ability, we can talk about this later, but for companies to bring competitive challenges before us. That's very similar to, I mentioned the NAD model, where you get Verizon brings a case against T-Mobile and they say, hey, you ran an ad that said you've got the fastest 5G and we don't think you do, and then you fight it out. So that mechanism also is available. That's another way where inquiries can start. We also receive consumer complaints and referrals from folks like non-governmental entities that are out there scouring, looking for claims as well. But the bulk of our inquiries over the past 5.5 years, I think we're up to what, Peter, is 540 inquiries, something like that.
Right.
The vast majority are through our own independent monitoring. And like I said, we partner with folks that leverage technology to allow us to do that. It's not Peter and I sitting here with Facebook and, popping around.
Well, that's great to hear.
Can I piggyback on that for 1 second? Because Howard
Sure.
just, Howard has all this great information too, and he always gets my wheels spinning. So I just wanted to touch on just a couple more things about DSSRC and our mission and what we're trying to do. So the whole idea behind what DSSRC and its mission was and is to really enhance public perception, regulatory, consumer perception about the direct selling industry, right? And provide this forum where companies can bring egregious, problematic income product claims to our attention, and we can provide this very expeditious system of review. And the last piece of the puzzle, and a big part of my job and Howard's job, is to publicly demonstrate the commitment that the industry has taken, Donna, not just to self-regulation, but to meaningful and effective self-regulation. And in kind of talking about our casework, I just wanted to point out there's this educational component that Howard and I have really worked to kind of put together. And it involves whether it's speaking presentations, whether it's published articles, whether it's the annual summit, right, that we provide. We feel, and what we've seen in the industry is that educational piece, working with compliance folks like yourself, working with guys like Kevin, who just have this breadth of knowledge that I know I learned from, and I'm sure everyone here can learn from. But working and collaborating with the industry, that's really what the DSSRC is.
Fantastic. Thank you
Yeah,
very much.
John Marie, before we move on, I just like to put in a plug
Go for it.
for Howard and Peter, because I've had the privilege to interact with them, in the last 5.5 years. They've identified claims that, some of my clients have had. And I think a lot of companies, a lot of executives in the industry don't understand the true role and the true value of the DSSRC. And so, as a preface to my comments, I'm not trying to blow sunshine up Peter and Howard's knickers at all. But honestly, getting a letter from the DSSRC, I think, is one of the best things that can happen for to a company, because what they've done is they've done a deep dive on a company with respect to whether it's product claims, whether it's income claims. And the entire purpose of this exercise is to help companies move toward compliance. That's incredible for that company. And it's great for the industry. Unfortunately, unlike the vast majority of civilized countries in the United States, sadly, our Federal Trade Commission does not see itself first and foremost as a consultant to the industry, really to provide beneficial guidance. I give you their penalty offense notice relative to income claims instead of taking the opportunity. And of course, they had the opportunity for decades to attempt to give guidance to the industry as to what constitutes a proper income claim or the parameters of a proper income claim. The FTC has never done so. So, I'm very grateful on behalf of the entire industry, on behalf of my clients, that we have the DSSRC. It's kind of like, getting a physical, and from your doctor. You may not like the news, but it's a lot better to hear it sooner rather than later. Howard, again, the breadth and the depth of Howard and Peter's knowledge is just incredible. But I think the most important takeaway for everybody in this call is just to understand, their entire purpose is to help your company comply. And that, again, that's great for individual companies, and it's great for the industries. And they're just absolutely awesome to work with.
Thank you. I agree with you, Kevin. They are. Let's talk about the current regulatory climate. Kevin, would you give us your opinion on the recent FTC actions and enforcement trends? We've had a lot of situations come up with Neora and Avocare. And what do you think? Are there going to be more companies that come up like Avocare and be challenged in that manner? Or let's hear your opinion on the recent actions.
Yeah, well, that's literally the $64 billion question. Again, I'm super interested to hear, Peter and Howard's perspectives, maybe Chris's as well. I don't think there's any question, but that the FTC got its head handed to it in the Neora case. I can't imagine how things could have gone worse for the FTC, at least from their perspective. We saw, once again, we see a federal court pushing back very strongly, against the FTC and its attempts to expand its imperial empire, pronouncements, attempts at legislation, etc. Of course, perhaps most of the folks know about the AMG Management Capital Management case from the U.S. Supreme Court back in 2021, which, in a 9-0 unanimous decision, the U.S. Supreme Court said, "Hey, FTC, you have no authority under Section 5 of the FTC Act to seek monetary relief." In response to that, it may be kind of a knee-jerk reaction. We saw them dust off an ancient remedy, the Penalty Offense Authority from kind of the 80s. We've seen them send out penalty, notices to a lot of companies in the direct selling industry, both on the income claim side and the product claim side. And I'm really curious. I'd love to get Peter and Howard's assessment as to what they think the FTC is doing right now in light of the fact that the notices have gone out. The entire industry has been put on notice about income claims and product claims. Hundreds and hundreds of companies have been put on notice. Gentlemen, what do you see potentially happening next in the industry with respect to these notices?
It's an interesting question. Howard, can I jump in on that one?
Sure.
It's interesting. And, Kevin, you mentioned the AMG Capital case and how that kind of, changed the dynamic a little bit, from where the FTC sits. And here, I'm going to share some inside baseball with you guys. Occasionally I have the chance to go in and sit, with the FTC, Division of Marketing Practices, and Lois Greisman. And they're their scrutiny of earning claims, and Howard mentioned this earlier, is just only becoming that much more increased and accelerated. You know, we talked about the knock on the chin that the FTC received in that Neora case, right? And if you look at that Neora case, which I believe was in what was Howard, the Northern District of Texas, and it was Judge Lynn, who essentially came down with a decision where essentially she denied every allegation that the FTC raised in that case. But I don't think the FTC had dotted its I's and crossed their T's when preparing for that case. I don't think Neora was the right company to go against because they had their ducks lined up. And if you really want to see good compliance work, look at some of the things that Neora really had in their pocket in that case. But I do think, here's what I do think. I think the FTC is loading up for bear now. I don't know what company is next on their bullseye, but you don't want to be that company. And if you are, oh my God, I can't emphasize enough that you better have your whole compliance framework really, really robust and ready for battle. Because I pity the next company that the FTC pursues.
Howard?
Well, it's interesting because I think the channel finds itself at this interesting intersection, right? Because you've got the commission sort of reeling from its loss, as it were, in Neora, and you have the AMG Capital in the background, which is, well, how is the commission going to seek monetary relief from anyone? That's why they sent out the penalty offense notices. They're looking at other levers they can pull in the statutory framework, and of course, we've got potentially an earnings claim rule coming down the pike that we're all going to see what that's about. But I agree with Peter's take that they're gearing up to go after someone. They're going to not make the same mistakes that they made in Neora. And what we can at least take away from what we're hearing from them is there is this renewed focus on certain things, right? Income claims. That is top of their priority list. They are concerned with false, misleading income claims. They are worried about statements made to entice new recruits. Their new business guidance makes that clear. They do not want exaggerated claims. They want claims that are substantiated by evidence. And there's this whole other focus, we touched on it earlier, but about expenses and how those expenses can essentially negate any claim of earnings. But again, while product income claims are still, I think, top of their priority list right now, do not forget about product claims. I mean, I think the Neora case began with a product claim. That's what got the regulators in the door. And then they start looking at things like the business model and earning claims and expanding their scope. And if you look at what the FTC put out, I guess now it would be the end of 2022, they put out their health product compliance guidance that tightened the evidentiary standard of what's needed for product claims. And just their general focus on deceptive marketing practices. And just last week, the FTC came out with a rule on fake reviews and buying essentially influencer positive or negative reviews. So it's an active commission right now. There's a lot going on with their looking for ways, as I mentioned, to seek monetary relief. But this channel has a bullseye on it, and someone's going to be the unfortunate recipient of that next case. But it's a very active commission.
Yeah, just one last thing on that, Donna, too. There are two areas, too, I think, where we're seeing some real renewed focus from the commission. Compensation plans, income disclosure statements, right? They're scrutinizing those two pieces very closely. And I'm not going to purport to be any kind of expert on compensation plans. I'll leave that to experts like Kevin Grimes and Chris Reed and Steve Richards and some of the other folks on the call. But I will say this, if there's an emphasis on the money being made coming from recruiting rather than product sales, that's where you're going to find yourself in the crosshairs. And that goes to the IDS as well. And the IDS now, it seems like it's open season almost on income disclosure statements. Kevin had mentioned, hey, there wasn't a lot of historical guidance given on the consideration of items for an IDS. But if you're putting together an IDS, and I've spoken to some of the stakeholders on this call about it, what they really want to see is who isn't making money from the business opportunity. And I think the real compelling question is segmentation, right? segmenting those sales force members who intend to go into the business opportunity versus those who are just there for, good prices on products and maybe, continuity plans and things like that. So those are two areas that I think the FTC is really focusing on, the IDS and the compensation.
Mhm, mhm. And with the letters that they recently submitted, one to you and one to the DSA, what was your opinion on that? Howard, what was your opinion on that? On those letters?
Well, interesting question. I almost take it back. This is again me just speaking my own personal opinion. I'm curious if Peter agrees or disagrees, but I almost think that it was in many ways almost a reaction to the Neora decision, because what Neora did in its compliance training and the like is actually footnoted that they followed some of our guidance. And I feel like in some ways the commission wanted to be very clear that just following our guidance wouldn't be sort of a safe harbor, so that wouldn't get used against them in future litigation. Putting on my hat as the former litigator, that's what I would be thinking if I was sitting over there. Okay, well, all well and good for a federal court to say you follow the DSSRC's guidance, but we don't want that to be sort of a get out of jail free card in the future. So we're going to say, you know what, the DSSRC, they can issue their guidance, but follow it or not at your own peril. But don't think that it's going to necessarily inform the way that the FTC sees the law. So that was my take on that. Pete, what do you think?
Yeah, Howard, I'm glad you took that question first because it allowed me a little time to think about the response. And here's what I'll say. First of all, it's kind of a little bit of a qualifier. DSSRC, BBB national programs, I know myself, I have great respect for what the FTC does and how difficult that job is. And having said that, I don't think there's anything wrong with a self-reg program like DSSRC. To respectfully disagree, maybe with some of the positions that the FTC takes. We get it. The FTC is an enforcement agency. Their approach on oversight of this industry is much different than maybe the collaborative approach that DSSRC takes. We place great value on the voice of the stakeholders. Again, a lot of the thought leaders who are on this call. We may not reach the same conclusion that the FTC does, but I think our perspective, because we work with this industry 24/7, 7 days a week, we really do. We're immersed in this industry. And I think our perspective is a touch different in how we approach it than the FTC does. So again, we respectfully, disagree with some of the positions the FTC took. Listen, that guidance document, Donna, it was exactly that. There was this historical void of any guidance at all regarding IDSs, and we just wanted to list some issues that companies should consider as they put this document together. That's all.
Kevin, what do you think of these letters, the two letters?
Well, I tend to agree with Howard's assessment. My adjectives might be a little stronger. To me, it just sounded like a sore loser letter. They're really been out of shape about the Neora case, and they obviously they want to continue to assert their position. From a litigation standpoint, they certainly weren't able to convince this federal judge of the merits of their position. But my concern really, I think, is a larger one. I think what we've been seeing since the mid 70s, that's when the famous, or not so famous, but at least cited by the FTC in its income claims penalty offense notice, the In Re National Dynamics case. Since that case was adjudicated by the U.S. Court of Appeals for the Second Circuit, we have had some guidance. In fact, it articulated 6 different categories of income claims and what's necessary to cure deception associated with them. And I love the language from the court in which it wrote. It said, in fashioning our modified order, we've proceeded on the theory that respondents should be allowed to make a wide variety of simple, truthful, non-deceptive statements concerning the earnings of their distributors. And again, the Imperial FTC has just over the decades attempted to constrict and constrict and constrict, and to not to paraphrase Howard's comments, but it seems like they're trying to get to the position that they contend that any type of income claim is deceptive, and clearly that's not the case. And again, I think as an industry, we absolutely need to be pushing back. We need to go back to the National Dynamics cases and take a look at what the U.S. Court of Appeals is saying about income claims within our industry.
Kev, it's interesting too, because I think one of the challenges that the commission has, listen, the SSRC has the same challenge, is kind of ascertaining who is the typical participant in a business opportunity, right? I mean, because the business participants in a direct selling company can vary so widely, right? From the entry level distributor to the triple, double, platinum, diamond guy, who's the 0.2%. And, when you have a social media post that's just making a general claim, hey, here's the opportunity to earn income, the rule of thumb is, okay, it has to kind of represent what could be generally expected by the typical participant. But there really isn't a typical participant, right? Because it seems like the breadth of sales force members, there's such a variance between what's typical and what's atypical there. It's really hard to put your thumb on what could be generally expected by the typical participant, right? And I think that's part of the challenge. Howard, do you agree with that? What do you think?
No, absolutely. And you raised some of these thorny issues, like how do you handle folks that might just do this on a seasonal basis, right? How do you take their annual income and you say, well, they only do it around the holidays or something? And this, you came back to this, Peter, and I don't think we can stress it enough, the whole idea of segmentation. And we've heard over and over again from the commission and elsewhere that you need to account for folks that don't make any income. But if they're not making any income because they have no interest at all in pursuing the business opportunity, that's something we'd want to know and carve them out.
That so many times when creating the IDS, that's the argument from the owners. How can we put the non-active people in there and not skew it to be so awful? Right. And the whole concept of adding the number of hours they're working and how much it costs them to work just seems so against what the IDS is. So it's very confusing to owners. I find with my clients, one of them has an IDS and is literally afraid and tells their distributors, their associates, do not make any income claims. That's it. Just don't make them. And they're trying to protect themselves, but they're making income claims. So how do you
Donna, the other thing the FTC is focusing on is a disclosure of material expenses that were incurred in realizing a certain income. And not just disclosing it, but clearly and conspicuously disclosing it in the context of an IDS, even in the context of the social media posts. Kevin, you've seen kind of where the FTC now has kind of changed lanes a little bit on this idea of modest and supplemental income, right? For years, this industry has been told, okay, forget the career level claims, or the career level income claims, and the replace your income claims. The direct selling industry should be about communicating the opportunity to earn modest and supplemental. Yeah. But it seemed like in that FTC letter that we received, the FTC is kind of backing off on that and moving the goalposts a little bit. And I just think that this adds to some of the uncertainty that I know a lot of companies are experiencing.
Well, we've determined that the moving lines are there and that they're moving. And however the FTC guidelines and enforcement strategies change, we have to adjust to it. So Howard, what's the implication of these changes for direct selling companies and their business practices? What do they do?
Well, I think it starts, I'm in the right place with the queen of compliance. The first thing you want to do is increase compliance. Potentially for companies internally to perhaps adopt stricter standards with respect to things like earning claims. But another thing that I don't think can be overstated is disclosures. I mean, famously, what it was Valentine's Day this year, Tina.org sent out letters to 100 direct selling companies about earning claims. Peter and I went through every one of those claims and we did our own sort of analysis, cataloged them into what we thought were claims that were too significant to be salvaged with a disclosure, all the way down to other claims that could be salvaged with the disclosure, including things like incentive trips and the like. Um, I think we had a significant percentage. I don't remember the exact number, but it's about a third of them, Peter. I think that we thought the claim would have been salvageable provided there was clear and accurate disclosure information about the potential earnings. So I think increasing compliance is number one. Obviously, I think in general, there's been a shift in business practices that companies are rightfully focused about genuine product sales over recruitment. We know that is historically going all the way back to the cases from the 1970s. That is something the commission looks at when it's looking at the business model. And then also just keeping an eye on consumer awareness. I mean, the FTC actions have, and not just the FTC. There's also, there's a law conference in New Jersey every year. It's the second or third time now. It's essentially an anti-multi-level marketing law conference for 2 days. There's podcasts. So these are all things that I think companies need to take into account. But again, we get so fixated on the earning claims. I just always want to come back to the product claims are a big part of this. Our jurisdictional charge at the DSSRC is to look at two things: product claims and earning claims. And I don't want to sort of let the product claims sort of fall by the wayside as we all rightfully try and interpret the moving lines on earning claims.
Mhm.
And again, I mentioned this earlier, but you see, this is a very, very active commission. So even things like testimonials and the like, the regulatory scrutiny is getting ratcheted up. Would you agree with that?
Mhm. Definitely agree. Kevin, could you tell us 3 practical examples of what constitutes crossing the lines in terms of compliance?
That's kind of a nebulous
With
question.
with compliance today, what would be 3 things that are examples of crossing the line with compliance? We know the income claims and the product claims, the compliance department. There's so many things that make up red flags for the FTC. What would be 3 of them that you would say, we know product claims, we know income claims. What would be something that practical that these companies can do right now to protect themselves?
Sure. Well, I mean, we all know that, the FTC's hot issues in direct selling are product claims and income claims. When we talk about product claims, and I see this all the time, is that, companies and their distributors are making claims, but I want to focus on companies because, the companies control 100%, the claims that, are made corporately. And, I'm always the guy who's asking them about their substantiation. They've all heard that word. They think they know what that word means, and then you have to break it down in terms of competent, reliable scientific evidence. And you have to, further explain, hey, here's the definition of competent, reliable scientific evidence. And this is what you're supposed to have in your possession when you first start making the claim. And I've only been doing this for 32 years, but the vast majority of time when I ask them if they have that, the answer is no. And it's like, well, to not have adequate substantiation that supports your claims, that violates the act, and that's a deceptive practice. And so your choices are, either get rid of these claims or, you better find a way to substantiate your product claims. And there are certainly a number of ways to do that, but it's surprising to me that lack of adequate product claim substantiation is such a perennial issue, and yet it is. And I think there's a lot of misunderstanding in the industry. And again, Peter and I value your perspective, but I think unfortunately a lot of entrepreneurs, a lot of executives think, gosh, if we have dozens or more great testimonials,
Right.
that will support our claims. And it's like, no, it won't. That's just a bundle of anecdotal evidence that will never rise to the level of competent, reliable scientific evidence. So I definitely see that as a hot spot. Obviously it's one that can be remedied. Again, the remedies are either get the substantiation in your possession or get rid of the claims. that's a big one, income claims, I think we've beaten that up fairly well. One thing that, again, I just like to give, Peter and Howard the opportunity to talk about is, we know that, probably the vast majority of issues and challenges and problems regarding income claims come from what the field is saying and doing, particularly on social media. And so I'd love to hear their thoughts and recommendations to companies about what they think companies should be doing relative to their distributors' income claims in social media or any other venue where they're prone to make income claims. Is there any way from the DSSRC's perspective that field leaders and distributors can do it right?
And this is great, Donna, because this is an opportunity to spice it up a little bit, right? So I'm going to push back, Kevin, just a touch on something you said. You're absolutely right. A lot of the claims that we see as problematic stem and originate from the Salesforce members. However, we're also seeing a lot of claims on company websites that kind of leave us scratching our heads sometimes. And that Tina investigation from earlier this year that Howard referenced, I would say at least 20% of what they identified came from the company websites, actually. And Kevin hit on it too, because what we're seeing on company websites are these testimonials, right? And as Kevin mentioned, that's anecdotal. Just because you have one consumer who's attesting about the great efficacy of a product or how much money they're making, that's not representative of what, again, could be generally expected by others in the field. And again, it's really important to have that disclosure in there, disclosing exactly what could be generally expected. So that's a very important piece. Here's one tip I would say, in terms of staying off the radar of these quantified earning claims: $500 a month, $1,000 a week. That gets you on the radar right away when you're making those very specific quantified claims. So those are just a couple of things, Donna, that kind of come to mind. And I just want to kind of, as I said, piggyback a little bit off what Kevin had mentioned. Yeah.
Kevin, what do you say when the representative says, but I can substantiate it? I can show you my bank account. I made this amount of money, or I can't substantiate it. They don't have reliable scientific data. What do you say when someone says, but it's the truth?
Yeah. Are you talking about a product claim or income claim?
Income claim.
Your
And
bank
let's do an
account?
income claim first.
Okay. Well, what I start off with is probably the most frustrating maxim in this industry, which is just because it's true doesn't mean you can say it. And being able to demonstrate, yes, I can show you my 1099, I can show you my bank account statements, I can show you my statements from the company that I actually do make $1,000 a month. I have made $1,000 a month for the last 12 months in a row from the company. Great, that's substantiation, but that bears not at all on the issue of non-deception. And so there are multiple requirements that the FTC has relative to any type of advertising. Substantiation is one, fairness is another, non-deception is the other. And the problem with income testimonials without the information that's necessary to cure the deception is all income claims are deceptive. And again, Peter, feel free to correct me, but I think the FTC's position is all income claims are deceptive unless the company provides all of the information that's necessary to cure the potential deception. And so, to me, I go back to case law, particularly National Dynamics, NRA Brock, and even the Amway case, that addressed income claims, because, we've got some direction and language from, the federal courts about income claims, which I think very conveniently the FTC wants to forget and gloss over, which is why I was extremely surprised to see them mentioning the, National Dynamics case in their penalty offense notice. But so anyway, that's my answer, is that, in any type of income claim that are typically made, that the one exception to that I would argue is not deceptive is statements of average earnings for all distributors. I think I think the National Dynamics case specifically addressed that and said that super limited type of claim, which nobody ever makes, that one is non-deceptive ab initio.
Can you give us an example?
Yeah, the average earnings of all of our distributors, and all means all, which includes the deadwood, the inactive, et cetera. If they're on the books as a distributor, they've got to be included in this number. The average monthly earning of all distributors is, $1.93 a month. If it really does include everybody, great. Now, again, we can certainly talk about, yeah, what additional information is needed, and again, I absolutely agree with Howard about what he's saying, that we're seeing not only from the FTC, we saw this from Bill Ackman and his attacks on Herbalife years ago, saying, hey, if you don't provide any information about the cost of doing business, because the ultimate issue is not how much you receive, it's how much you keep. And so, to not provide any information about the expenses of operating your business, that's deceptive. I understand that argument. I appreciate that argument.
Peter, comments?
Yeah, there's one kind of piece from that New York case that I always found really interesting. And I think this is where the FTC might lose a little sight of that. There was a footnote in there about going to a grocery store. And yeah, you may go into a grocery store and lose money, but you're still getting something of value, even if you're not realizing positive income or if you're losing a little bit of money. And that's what this industry is all about, right? It's not necessarily all about earning the money. It's about the networking. It's about the education. It's about the creation of a community, right? And I think that's such a valuable piece that sometimes gets omitted from the global thinking on this. Howard, any thoughts on that? You see how I pass the buck to Howard all the time? Howard,
So
Oh,
I actually wanted to go back to just something that Kevin was touching on, which is the kind of the maxim that just because it's true doesn't mean you can say it. Because it just reminded me of when we mentioned we started this program 5.5 years ago, and testimonials are such a big part of the types of claims you see out there, right? We all know that. When we started this program, we would often commence a case inquiry about testimonials. And folks would say to us, well, that's not an earning claim. That's just a truthful testimonial. So I think we've moved, industry education has moved quite a bit where people now understand that a testimonial is a claim. But I think Kevin makes a great point that just because someone can say, hey, here's my 1099, this is what I actually made last month. That really goes back to like the FTC guides on endorsements and testimonials, that the average person will hear that and their takeaway will be, that's going to be me. And that's why as Kevin said, there's a much different threshold for saying like, hey, the average distributor for everyone in the company made X versus sort of a significant high performer touting their own success. It's the same way that the commission would look at, say, an extreme weight loss claim. I say, okay, I drink this green tea and I lost 40 pounds in 2 months. Well, if that's not what the typical person can expect, then that's going to be a claim that's misleading unless it's cured with a very, very clear and prominent disclosure.
Yeah, and Howard, the one term that it's amazing we haven't talked about in an hour of direct selling conversation is the term financial freedom, right? And
Yeah.
I think one of the things that DSSRC has helped companies with is to really reconsider financial freedom, the financial security type of terms. And those are the terms that the FTC and the state AGs are out there looking for, because it goes back to that 1983 substantiation policy of being able to support any reasonable interpretation of a claim. Financial freedom claim really opens up the potential various interpretations that a consumer can take away. And again, the burden is to support any reasonable interpretation. That's a hard burden for a general financial freedom claim. And we've, again, talked with a lot of the thought leaders in the industry about this. And I think we came to a general consensus. You don't want to be making financial freedom claims.
mm-mm. Or supplemental income claims?
I think that's a little less problematic from where we're saying things. But, again, everything is couched in context. It's hard to look at these statements in a vacuum without seeing how it's presented in a social media post, in an ad, on a website. Because it's really, again, goes back to net impression. What's the net impression of the entire advertisement?
I did get a couple questions and I wanted to ask the three of you about this one. What
Hey,
about
Well,
other
Donna Marie,
people's?
could I just run
Oh,
a
sure.
question past Peter
Go
and Hal?
ahead.
I mean, we've been talking about this, extremely large topic called compliance. And, the fact of the matter is, that we use a lot of words in the industry, like we have, absolute clarity on what they mean. But, compliance is kind of a little, to a certain extent, a little bit of a nebulous, specious term. I'd like to ask, your thoughts about when you talk about compliance, what do you see or what do you think is important for companies to be doing right now with respect to compliance? And sorry, whoops. Um, what are what goes into a well-designed compliance program? You alluded a little bit to Neora's. What do you see at an industry level? What do you see the industry doing well when it comes to compliance? Where do you see the industry lacking with respect to compliance?
So I can jump in, Pete.
Mhm.
I guess what we see the industry doing well versus not doing well, that's kind of a tough question because it's very often company by company. It really depends on the size of the company, their budget. But I think there's some certain um, basic guidelines that companies would do well to follow, right? One is to have a robust compliance program. And it's your question, Kevin, what does that mean? It really means having clear guidelines for what the field is allowed to say about earnings, about product claims, making sure that the claims that are out there are truthful, substantiated, not deceptive, and that the company has substantiation to back them up. Regular training for Salesforce members. I mean, that's something all companies should be doing. To make sure that their sales force are being educated about what the guidelines are, and hopefully the company guidelines are in sync with what both the DSSRC and some of the regulatory authorities are putting out there. Getting training. I mean, Donna Marie does it. Companies have often their own in-house training. I mentioned that we use monitoring. I think most companies, if they can absolutely in any way afford it, should be leveraging some of these companies that use technology and data to go out and identify potential issues so that the companies can act on them before they end up on a state AG or an FTC radar. Someone at the company, whether it's a compliance officer or the chief legal officer, needs to be staying up to date and trying to follow the FTC trends. I know we're all sometimes scratching our head as to where the line is, but companies would do well to try and stay on top of that. Leveraging outside counsel, folks like you, Kevin, and also internal compliance officers. And then the last part is, Peter touched on this. Our charge, DSSRC, a lot of it is collaboration and education, and collaborate with us. I mean, I look at the folks on this call. We've had one-on-one calls with a number of you. We're here to try and promote ethical business practices in this channel. And when companies are grappling sometimes with issues about how to present a claim, how to craft an IDS, is this disclosure effective? Peter and I are a phone call or an email away. So those are just some thoughts, top level on that question.
Peter, any additional comments? And then we're going to go to a couple questions in the chat.
Yeah, just one last thing, Donna. I think from a compliance standpoint too, it's so important to be able to demonstrate that you're making a good faith effort to address maybe concerns from the DSSRC or from some others out there, right? And I'll give you an example. One of the big challenges companies have is we'll identify a social media post from, 2021. Maybe the person who was responsible for that post is inactive, can't be found. Still, have that correspondence where you reached out to them. Did you try to contact the platform? Did you think about even adding a comment, somewhere on the post? The other thing, and I've had the good fortune of administering several different self-regulatory programs over the last several years. One of the great things about the direct selling industry is this group of thought leaders and stakeholders and availing yourselves. Again, not to sit here and flatter Kevin Grimes. He's fantastic. You can call him up. He'll speak with you. We have a group over here, the Plexus guys out there in Arizona. whether it's Kim Graven, Chris Reed, Carmen, that group, they're fantastic. And they're willing to share thoughts with other companies. So you have this great kind of reciprocity amongst companies. And I just think companies should really avail themselves of the expertise of others in the industry. And that does include other folks over at the DSA. You know, again, Steve Richards, I think, is on call. He's another great, valuable voice. So,
Well, let's
Always good
answer a
back.
couple questions from the chat. I've got a question from Bruce Murdoch. He's also an attorney, and he's asking how have companies typically responded when the FTC has come after them for income claims that have previously been considered okay, make supplemental income, help pay your bills, those types of questions, statements. Who can take that?
Yeah, this one, Kev, this has you written all over.
Yeah. Okay.
Thank you. Well, how companies typically responded. So the FTC commenced its former litigation strategy in 1996 against a company called Jewelway out of Tucson, Arizona. I call their, former litigation strategy the silver bullet, one-shot judicial assassination litigation strategy. And so typically, in the complaints that the FTC has filed against companies, in addition to alleging that the program, the company was a pyramid, they've also lobbed in, usually one or more income claims. And again, that has been the case since 1996. I remember, gosh, probably 15 years ago, I went and looked at every single complaint that the FTC had filed against direct selling or purported direct selling companies, and every complaint included income claims, deceptive income claims. As probably most of the folks on this call know, in the vast majority of those cases, the FTC was, and of course, their litigation strategy also involved, with contemporaneous with filing the complaint, they filed an ex parte motion for a TRO, requested, the asset freeze, receiver appointment, et cetera. And the FTC was incredibly successful in getting its requested relief. And the net result of all that is, the FTC put companies out of, and I'm not saying a lot of them shouldn't have been put out of business, but they put a lot of companies out of business before the company even realized that it was out of business. And for almost all of these companies, there was no way that they could recover from that. Interestingly, when the FTC sued Herbalife in 2015, it didn't allege that Herbalife was a pyramid. They alleged unfair, trade practices, but they also did not pursue, the ex parte TRO, asset freeze, receiver appointment, et cetera. But the number of companies that have been victorious against the FTC, I think we could probably count on one hand, with First Euro being the most recent. But yeah, so generally, it wasn't just about the income claims. There was also the pyramiding piece and some other pieces. But the net result of the litigation for the vast majority of companies is they were ground into fine powder and put out of business.
Terrible. Poof, they were gone. All right. Well, Bruce, did that get your question answered? Where is he? I don't know if he's online. All right. Another question that's come up is, what about testimonials from other people? I've heard from different attorneys the answer to this, and I'm confused about it as well. Can I say my aunt had this result? My child had this result? Or does it have to be the actual person making the testimonial? Kevin?
Well,
You're right there.
Yeah, like I mentioned earlier, and Howard alluded to it too. Yeah, just because it's true doesn't mean you can say it. Your Aunt Susie's second cousin's, experience with the product is, I'm sorry, it's irrelevant. I mean, I'm happy for Aunt Susie's second cousin, but in terms of being able to make the claim totally unsubstantiated. And so, the making of unsubstantiated claims violates the FTC Act. So obviously my recommendation is don't go there. The only testimonials that should show up anywhere are testimonials that are separately substantiated by competent, reliable scientific evidence. So for example, if the company has great substantiation for its claim that, hey, this product helps support immune health, wonderful. And Aunt Susie wants to say, yeah, this product is great in terms of supporting my immune health, wonderful. But she can't talk about it, preventing, curing, treating, or mitigating her lupus.
Okay, great. Thank you so much. That comes up often. All right, I believe that we have come to, oh, I know, I still have a couple questions. How can companies anticipate and adapt to the regulatory changes? We've already talked about that pretty much, but Kevin, what's the role of legal counsel to help get the companies to do the right thing? I know you can only suggest and go so far. It gets me as a consultant because I'll see things and think, wow, they shouldn't be doing that. And the owners think they know everything about what's going on with their company and what they can legally do. So what's the role of legal counsel when it comes to trying to sway an owner in the right direction?
Well, I think, like Peter and Howard, well, actually, they can do more than I can do, but in terms of persuasion, but yeah, just, explaining the law and also, giving them a picture for what happens if you violate the law, in terms of product claims on the FDA side. There are all sorts of warning letters that are out there. I mean, I have a massive library of, hey, you want to say that this is an immune booster. Well, that's problematic, and here's why, and here's some warning letters that support that. In terms of substantiation, again, because that's so cut and dried, when they don't have any. Again, so it's very easy to, help them understand. It's like you don't have any substantiation, and you have to have it. Here's what that looks like. There are a couple. I call them scientific literature researchers that do masterful jobs of putting together substantiation packets for specific products, all the claims that are being made for that product, but they also give counsel. It's always the lawyers who are raising the issue of substantiation, but everybody needs to understand that substantiation is first, foremost, and by far a scientific exercise than it is a legal one. I don't know if Peter or Howard have a scientific background. I don't. And so, I cannot opine as to whether, this body of information passes muster as competent, reliable scientific evidence, but there's no shortage of folks out there who can do that. So, if companies, like I mentioned earlier, if they don't have adequate substantiation, they either need to modify, drop drop their claims, or get adequate substantiation. But so in terms of effectively using your attorney, it's just ask the questions and be open to the feedback.
And listen to them. Be open to the feedback. Listen to them. That's the thing. All right,
Kevin,
let's
it's
do
a-
a let's do a quick recap. Howard,
Kevin
go
said-
ahead.
No, it's just, you mentioned companies not having any substantiation. The other issue that we see quite a lot is where the company does have substantiation, but maybe it's not a good fit for the claim that's being made. So let's say you have a product that has 4 different active ingredients, and you have individual studies on each of the 4, but you don't have a study on the completed product with all 4 working together. Something like that, where the company may, in their own minds, rightfully think, well, no, I do have, look, here's my studies, but it probably falls upon someone like Kevin to explain to them, okay, you have some evidence, but that's not what we need, and it's not reaching the sort of the evidentiary threshold.
Okay.
And here's where the scientists are really good. Again, the ones who specialize in doing this, they'll go out, they'll do the research, and they say, hey, I found 8 studies, that relate to your claim. Now, in terms of their protocol, their size of duration, 3 of them are absolutely worthless. Okay, but these 3, instead of being able to make the entirety of this claim you want to make, you can make about 60% of it. So you need to modify your claim, bring it back to X, and these 3 studies absolutely will substantiate the modified claim, but they won't substantiate your claim as you're currently making it. Again, so that's a tremendously valuable exercise.
Mhm.
What a great thought, Kevin, too, and kind of combining what Kevin and Howard just said. None of us purport to be scientists here, but I think we could ascertain what's a good study and what's not. But the important thing is what we have to do is figure out whether or not the science matches the claims, right, that are being communicated. I think that's where we can come in. Again, we're not here to necessarily question the science of it, but really the applicability of the science to the advertising. And that's kind of where we help.
Okay. Well, thank you, gentlemen, so much. We're going to wrap up. I want to go to each one of the three of you. I'll start with Peter, then Howard, then Kevin. Just wrap up the conversation, if you will, from the DSSRC standpoint, Kevin, from a legal standpoint. What have we learned here today? That the lines are moving, and you've got to adapt by being flexible to the lines moving to fix whatever the problems are. There's no fighting with the FTC. We've got to work with them.
You know, and I think that's right. And one of the key things I think is being responsive, right, to these issues, not just burying your head in the sand and pretending they don't exist, but participating in conversations like this with industry experts like this group on the call. Again, the great value of this industry are the thought leaders, right? And here's a great opportunity to avail yourself of those thought leaders and just staying aware, as Howard mentioned and Kevin kind of emphasized, this evolving regulatory landscape that we're in. It's there. We have to essentially acquiesce to it in a certain way. And again, just be responsive to it, right? From a compliance standpoint.
Great response. Howard?
Yeah, absolutely. I mean, as Peter said, the landscape is changing. This is a channel under scrutiny. There's going to be a company or more than one company that's going to be the next recipient of a large regulatory action. So, you know, as Peter said, don't sort of bury your head in the sand and say we're going to do things we always have done them. Try to stay abreast of best practices. And as Peter said, you know, going back to the financial freedom question, I mean, we talked about the New York case. There's financial independence and financial freedom claims cited in that complaint. You want basic things like that to get your company, hopefully, to stay off the regulatory radar.
Mm-hmm. Kevin?
Well, I'd say a big issue, kind of one that nobody wants to talk about, is related to an article I wrote a couple of years ago, the title of which was, you know, why do direct selling companies keep getting in trouble for the things that other direct selling companies have been getting in trouble for decades? And I mean, I've only worked with 1,500 companies so far, but what I say is we've got a challenge, particularly in the C-suites, with respect to teachability. And I love the quote by George Santayana, who said, "Those who neglect history are doomed to repeat it." And so, honestly, we've got a substantial challenge in the industry that most of the folks who are in it are extremely poor students of its history and the great lessons that they teach. And so, you know, yeah, again, you know, the attorneys on this line, you know, like Steve Richards, like Peter, like Howard, can give the world's best legal advice, but if the client's not willing to hear it and put it into practice, it's not going to help them. So I guess my encouragement to you know, decision makers is to be teachable.
Thank you very much. Great advice, gentlemen. By attending this session, hopefully you gained valuable knowledge about the current state of the FTC. You learned more about the DSSRC, and you've learned how to protect your company from potential enforcement actions. So listen to the experts. They've been there. They have the experience. They know what they're doing. When I get a startup company that never had any experience in the direct selling industry and they know everything, I want to shake them. So be willing to learn and listen and really implement what the professionals do tell you. This show is essentially for business owners of direct selling companies, compliance officers, legal advisors. So when you get the replay on it, forward it to your owner. Rick Gray is holding up my book. I forgot to mention it. Thank you, Rick. I did write a book. The first book is available on Amazon. If you have any questions about setting up a compliance department, let me know. I'd love to send you a copy of my book. So we're thrilled that you joined us here today. Thank you so much. Thank you, Peter. Thank you, Howard. Thank you, Kevin. It is always a great conversation getting industry experts together, and you guys did not let us down at all. So
Not at all.
any
Not at
questions
all.
that are in the chat, I'll get them to you folks and we can answer them directly.
Great.
All right. Thank you, everybody. I look forward to another conversation in the future. I'm sure we could put on a week-long session, and that's where training is going to come in handy in October. So thank you again, gentlemen. Thank you all for coming and joining the call as well.
That's a
Take
pleasure.
care.
Thank you.
Thank you.
Thanks,
Take care.
Kevin.
Have a good day.
Thanks, Howard.